Okay, so hello everyone. In this session, we're going to be talking about one of the key topics of administrative law, which is about unauthorized decision-making. And it's a crucial topic because we often have to wonder whether or not every time the executive makes a decision, whether or not there is a need for that decision to be based upon a law, and in particular, whether that law has to be based on statute, or whether or not there are certain powers that the executive can exercise, such as the executive power under Section 61 of the Australian Commonwealth Constitution, as well as the fact that there are certain inherent powers which are considered to be part of every executive, even in the absence of a written constitution. In other words, for any executive to be able to function, even in the absence of a constitution, it should have certain powers. So that these are what are known as inherent powers or prerogative powers. So it raises the question of whether or not when the executive makes a decision, whether that decision has to be based on a statutory authority. So if it's statutory authority, it's an authority based on a statute or an act of parliament, or whether or not it could rely on some other power. And the reason why that's crucial is because assuming that it can be alleged or claimed or asserted that the decision of the executive is unauthorized, either because there is no law that authorizes that decision, or perhaps because even if there is a law that authorizes the decision, that decision may be what is known as ultra vires, meaning it's beyond power, then that would be a ground for a review of the decision, either on the basis, either as a part of a merit review process or a judicial review. And so this is the topic we will be focusing on in today's session. Now, so the recording is on. Now, before we start talking about this particular topic, I wonder if there might be any question or any comment that any of you would wish to raise at this point. Comments, questions, before we continue? None? And yeah, and so far I want to make the comment that I've had a look at a number of assessments that have already been submitted for our course in relation to the group-led Moodle discussion. And a lot of them are of really high quality, which is really good. And I suppose that not only is it because, I suppose you're year 2 students and a lot of you are quite familiar with the way that you should be writing legal papers or legal documents, but I suppose it's also the fact that you've benefited, I suppose, from feedback. And I just wish to kind of remind you that I had sent an email, I think it might have been yesterday or 2 days ago, where I was hoping to solicit some feedback from you through the student early experience survey that I posted and created in SurveyMonkey. And that survey enables me, therefore, to examine what areas need improvement, what areas seem to be working quite well, and the ways by which I could probably enhance the delivery of this particular course. So I'm hoping that you might be able to spend the time doing that survey. It shouldn't take more than 5 minutes. Likely very much less. And I'd be very grateful for that. Okay, so having said that, and on the assumption that you don't have any questions in relation to any of the topics that we've previously covered or in relation to the assessments, then we will proceed with a discussion of tonight's topic on unauthorized decision-making. So in terms of key outcomes, after studying this topic, you should be able to discuss and explain, 1, whether legal authority is required for every executive decision or action to be made. 2, whether you should, and after studying this topic, you should then be able to discuss and explain unauthorized decision-making and the types of executive decisions and actions that do not require specific legal authority. Now, let's begin with a backgrounder, a kind of a fundamental question about administrative law and as to the scope of judicial review. And the question goes this way: judicial review is said to be of limited scope that focuses on the process of decision-making, such as the observance of fairness, procedural fairness, and natural justice, and does not really examine the decision itself. In what circumstances is judicial review said to involve a review of the decision itself? So the substantive aspect of the decision. So in what instances is judicial review said to involve a review of the decision itself? Any volunteers? Any attempt to answer that question? And just turn on your mic if you would like to answer that question.
Manjo, I'll have a go.
Maria, yes, go ahead.
It's about how they arrived at the decision they ended up making. It would involve a whole lot of things. Oh gosh, I lost my train of thought. Okay. Basically, they wanted to make sure that the final decision is fair. And they need to establish how they arrive at the decision. And if indeed it needs to be reviewed, they will look at the whole thing, how the courts ended up with a decision. I'm going round and round and round. I've lost my train of thought.
You're actually correct there, Maria, but so you're correct. That's the typical way by which judicial review occurs. And that's really examining the totality of the decision-making process. And as we said, so in that case, if there seems to be a failure on the part of the decision maker to observe procedural fairness or natural justice, or that he may have exercised his powers in an arbitrary manner, again, focusing on the process of decision making, then certainly judicial review is likely to be available, and a decision is likely to be favorable towards the aggrieved. Now, but what I'm hoping to elicit from all of you would be a question that relates in a sense to a kind of a review of factual matters. So we know that if there is a question about an administrative decision and there is an attempt to impugn the validity of that oh wait, there was an echo there. Okay. I don't think that came.
Yeah, Manjo, it's just, are you, yeah, Scott Wellburn here.
Yeah, go ahead. Yes.
Is it where the decision's unreasonable, so that no authority or tribunal or reasonable authority or tribunal would have come to that decision?
Very good. So that's exactly the point. And this is called Wensbury unreasonableness. So typically, very good, Scott, and thank you for that. As we said, when it comes to a question about factual matters and whether or not an administrative decision was correctly arrived at on the basis of the facts, then in that case, the only available remedy would be to have merit review, assuming that it is permissible, for example, under the Administrative Appeals Tribunal Act. And in other words, there is also a statute that authorizes a merit review by the AAT, so that it is not within the scope of judicial review to examine factual matters. Okay, because as we said, if there is a judicial review, the judicial review is limited to examining the legality or lawfulness of a decision. In other words, the question is whether or not the decision is according to law. So it doesn't examine factual matters. But on the basis of what Scott said pertains to Wensbury unreasonableness, when the decision of an administrative decision maker, even though it is based on facts, is such that it shouldn't have been possible for a reasonable authority or a reasonable body to arrive at a decision on the basis of the facts, then it can be said that the decision is unreasonable. And it is what is known as, it meets the standard of what is known as Wensbury unreasonableness, although it relates to the facts, but the decision of the administrative decision maker, although it is based on the facts, is so unreasonable that it is in fact open to judicial review. So it is only in that limited area that it can be said that judicial review is open to examining a decision on the basis of factual matters, because it is said in that particular case that the decision was arrived at on the basis of an examination of the facts, and yet the decision on the basis of the facts is so unreasonable that there is no reasonable authority or body that should be able to arrive at that decision. Now, I think there was a chat somewhere. Let me check. Chat. Okay. So from Grace, would it also be the case that there is no evidence to support the decision? Very good, Grace. So as we will examine, I think in succeeding chapters, it is also true that when a decision, and this is in fact separate from the notion of Wenspree and reasonableness, when in fact there is no evidence to support a decision, that will also be a ground for judicial review. And the basis for that is that when a decision of an administrative decision maker is made in the absence of evidence, then clearly there is an error of law or there is an illegality in the decision. So the decision would be illegal or unlawful. Okay? So in that case, it is the unlawfulness or the illegality of the decision because there is no evidence that would be the basis then of judicial review. But on the other hand, as we will know later on, even if the administrative decision maker makes a mistake in appreciating or evaluating factual matters, and even if it is clear that the error is that the decision is erroneous on the basis of the facts. So the decision, as I said, is erroneous on the basis of the facts. So there is clearly an error in the decision of the administrative decision maker that will not permit the exercise of judicial review. So it's either only when there is Wenspree and reasonableness, in the sense that when an administrative decision maker makes a decision on the basis of the facts, and that decision could not be reached by a reasonable authority or a reasonable body on the basis of the facts, that amounts to what is known as Wenspree and reasonableness, which would allow for a judicial review, or when, as pointed out by Grace, there is simply no evidence that supports the decision, and because of the absence of evidence, then that decision is unlawful, illegal, or unauthorized. Okay, questions? So thank you for that question, Grace. Comments? Okay, let's move on. Okay, so discussion question 2. Lord Chief Justice Camden's statement in Antic versus Carrington is the foundational statement of the common law principle of legality. He said, by the laws of England, every invasion of private property, be it ever so minute, is a trespass. No man can set his foot upon my ground without my license, but he is liable to an action, though the damage be nothing, which is proved by every declaration in trespass, where the defendant is called upon to answer for bruising the grass and even treading upon the soil. If he admits the fact, he is bound to show by way of justification that some positive law has empowered or excused him. The question is, or the questions are, 1, what does the principle of legality mean? And 2, does it mean that every executive decision, in order to be lawful, must be supported by a specific legal authority that authorizes that decision? So this is a crucial question, because you've got to wonder, does it mean that every time the executive undertakes a specific action or makes a decision, must that action or decision be supported by specific legal authority, and which typically can be in the form of a statutory authority, meaning a law or statute passed by the parliament? Can I have a volunteer?
Hi, Manjo, it's Tamara.
Oh, okay.
Mara, yes. Was there somebody else who wanted to speak as well? Well, okay, let's just begin with Tamara. let's begin with Tamara. And if there's somebody else who wants to say something, just pick up the mic or raise your hand. Okay, thank you, Tamara. Go ahead, please.
All right. So the principle of legality, I understand it as it's about infringing like persons' rights and I'm a bit like Maria, I've lost my train of thought. So when you're looking to infringe a person's rights and values, you've got to, when you're sort of putting forward legislation, you've got to make it very clear that that's what you intend to do, so that it's, I suppose, in a way, it sort of legalises infringing people's rights. But I read as well that within that there's, I don't know that scope is the right word, but there's scope for the legislation makers and decision makers to abuse that as well. So it's sort of abusing their power. So it sort of goes outside of, no, I think I've got Maria's disease. Sorry. Yeah, so it's just sort of, you can't sort of go beyond what the law is allowing you to do or authorising you to do. So if you want to go beyond that, you have to say that that's what you intend to do, but there's sort of, they say that there's scope for people to still abuse their authority, I guess. Anyway, if any of that makes sense. Sorry.
Yes, it does. I'm going to ask a few questions about that in a short while, Tamara, but I'd like to give Lauren a chance to say something because I saw her raising her hand. Lauren.
Yeah, I was just going to contribute to answering the question, but I guess the way I understood it was the principle of legality is that the executive is still bound in general when making decisions to the law. And so what was decided in, Entic v. Carrington, was that in terms of, does the decision made need to be supported by specific legal authority, is that bearing in mind that the executive is bound by law, and what the Commonwealth states is that it's only when an individual's rights or interests are going to be impeded on that reference to a specific piece of legislation or law needs to be provided as to reason for why they've come to that decision. And I reading over the notes that you released in the study guide, Manjo, about if the executive was required to provide such evidence for every decision that they made, that would severely impede on their ability to do their daily functions in terms of administering their daily activities and what they need to do. And obviously that would create a massive backlog and backload if they didn't have those inherent powers to just be able to do their ordinary daily responsibilities. But then if decisions are then going to affect a right, according to, I think at the front it was common law rights and freedoms such as procedural fairness, etc., then that's when specific legislation and law must be referred to.
Very good. Was there any other comment from anyone else? So thank you, Lauren. Lauren explained it quite well. Questions?
Can I just add to that what Lauren said,
Yes.
Manjo?
Yes.
Yep. So I think sort of, like, I agree with what she's saying in terms of, like she said, if you had to provide reasons or, you had to sort of justify the decision, that every single decision that you made, it would just become this huge burden, which kind of sort of counteracts the whole point of making decisions and merits review and judicial review in terms of, it's meant to sort of make access to justice easy and sort of make everybody accountable and sort of things like that. So the more burdensome it is, the harder it is to sort of realise the whole point of administrative law. And then I was reading through the textbook this afternoon, and there was a part in it that said, fairness is not an abstract concept, it is essentially practical. Whether one talks in terms of procedural fairness or natural justice, the concern of the law is to avoid practical injustice. And I thought that sort of explains what it's all about, like this sort of processes and procedures like everybody has to go through, whether you're the public or the decision makers, in order to be accountable and to make it all decisions fair, I guess.
Thank you. Anyone else who would like to contribute to the discussion? Okay, so to sum it up, as correctly pointed out by Tamara, as well as by Lauren, there is no requirement that every single action or decision of the executive has to be supported by a specific statutory authority. And when we say statutory authority, again, we mean that it is an authority that is based on statute or a law passed by the parliament. There is no requirement. And the reason for that is that if the executive were required to provide or show a positive law that authorizes or enables it to act in a particular way or to make a decision, then it would make it very difficult for the executive to act and undertake its functions. So that's one. So in other words, even in the absence of a written constitution, it is understood and assumed that the executive should be empowered to make decisions and act even in the absence of any positive law. So common law recognizes that power of the executive. Now, as important, it can be said that Section 61 of the Australian Commonwealth Constitution, in fact, authorizes the executive to act in the exercise of what are known as executive power. So the executive power is vested in the executive as exercised by the Queen in Council. So there is a constitutional recognition that the executive has executive powers. And that would suggest to us, and that would tell us that there is in fact a mandate coming from the Constitution which allows and authorizes the executive to act. And the only instance when there is a specific statutory authority or positive law that is required in order for the executive to act or decide in a certain way is when those actions or decision would tend to infringe or impair upon the rights or freedoms of citizens or its subjects. So as pointed out by Lauren, for example, when the decision, for example, might involve a breach of natural justice, or it might mean in impairing the freedom of a person, or which would lead to an arbitrary detention or arrest. In those specific cases, there is a requirement that there has to be a positive law that authorizes the action or conduct or decision of the executive. But otherwise, there is no requirement for there to be a positive law or a specific legal authority that authorizes the executive to act or make a decision every single time. Questions? None? Okay. So discussion question number 3, the Minister of Health created a health awareness program that provided a budget of $20 million for a program to promote awareness of men's depression as a health issue. Red Manson asserts that the program is rubbish and has called on the minister to withdraw the funding, claiming that the money is better spent on other programs in the current economic environment. He also asserts that the minister has no legal authority to make the budgetary decision. When the minister refused to revoke his decision, Manson considered filing an application for judicial review on the ground that the decision is unauthorized. He has come to you as solicitor. What would you advise him?
Well, first of all, he'd have to go for merit review, would he not?
Okay, let's examine that first. Do you suppose that merit review would be available in this instance? Just give me a few seconds. I'm just gonna close the door. It keeps on banging. Give me a second. Okay, thank you, Tamara, for your comment. So I go back to my question. Would this, on the basis of the facts, would merit review be available?
Manjo,
Yes.
Scott here.
Yes.
I don't think so. Firstly, I don't think this gentleman has any standing.
Mm-hmm. Wait, before you do that, are you responding to the comment that was raised by Tamara, or are you responding to this specific problem and its question itself?
Just the specific question itself, I suppose. More
I was hoping for somebody to comment on Tamara's comment. So my
well,
question...
could it be done by merits review? It's a policy decision. It's not...
Okay.
It hasn't been a decision affecting anyone. It's just a political policy decision.
Okay.
May I? I would think that this is probably a question of law, whether the ministers got the power to make a decision. And I would think it's for the judicial review, that particular section.
I missed that part about your conclusion, Grace. What exactly?
I would be thinking that the question is whether this is I'll start over again. Whether the ministers got the power to make a decision, he did, and another question is that whether he's got whether the whole process is for the merit review or for judicial review.
Okay.
And I think it's probably related to the judicial review, because it's whether the ministers got the power, the legal authority to make this decision.
Okay. I'm going to go back to the issue about judicial review in a short while, but in the meantime, I'd like really the class to think about the idea that potentially merit review is available in this instance. What do you think?
No, Manjo, I don't think it is. Like, what legislation would give authority for the AAT to conduct a review into this? I mean, it's a political decision about allocating budgets. It's not an issue under the Health Awareness Act that gives the power to the AAT to review its decision. There's no authority there for the AAT to conduct a merits review.
Okay, so that's yes. What was that? Somebody wanted to say something.
Oh, that was me, Manjo. It's Maria.
Yeah, yes, go on.
Really, for Red Manson to have some sort of standing, he has to show what interest he has, whether he belongs to some organization that is adversely affected by this health awareness program. On the facts provided, it doesn't look like he's got any standing or any interest at all that would be affected by this program. So I don't think he'd have, I don't think the AA or the merits review would be suitable for whatever issue he has.
Maria, on that point, and I'm going to go back to what Tamara said in a short while, but on that point, when exactly can it be said that a person has legal standing? And because that was also suggested by Scott.
Sorry. Well, he'd have to be, it looks like he's just an individual. It doesn't really say whether he's a representative of some sort of an interest group. So he'd have to belong to an interest group that would be affected by this program, or whether he belongs to an organization or some association that could challenge the decision by the Minister of Health. It looks to me, on the facts provided, it looks to me like he's making some sort of political stand.
Sorry.
That's right.
Really?
That's right.
Just to oh, sorry, Manjo.
Go ahead, Tamara. Go ahead.
Just to add to what Maria was saying, like, I know I may have made the sort of wrong answer before in saying merits review, but in terms of when it's sort of like a decision that perhaps affects like a group, like a select group of people, only an individual can ask for a judicial review if it affects them specifically within that class of persons. Is that correct?
Yes.
Whereas if they can't prove that it doesn't affect them specifically, well then, you know, sort of bye-bye, see you later.
Okay, but would it be sufficient for a person to say that he has been specifically affected I mean, when a law, for example, is passed, and for example, in this particular case, when it can be said that the benefits that a person would probably be getting would now be less because of the decision of the minister, then that person can say that he has been specifically affected by the decision, right? I mean, if the parliament were to change its law so that in terms of the family tax benefit, instead of somebody getting, let's say, $200 a week, somebody would now only get $100 a week, it can certainly be said that that person has been affected specifically by the decision of the minister. But the question is that sufficient to provide legal standing? And that goes back to my question of exactly how is legal standing understood? So in other words, is it enough to say that somebody has been affected by a decision? Is that enough? Or how exactly do we define legal standing? I actually saw Lauren raising her hand. I wonder if Lauren wants to say something.
Sorry. No, I was going to come back to something else that wasn't specifically in response to that question. So, sorry.
So we're going to go back to you, Lauren. Okay. Any comments from others? Yes. Was that Scott?
Yeah, Manjo, doesn't it have to be that it's like his interest must be one that he holds specifically, not just as a member of the general public, and it can't be too remote.
That's right. So going back to the issue of legal standing, it is insufficient for a person or an aggrieved to claim that he has been affected by the decision, even assuming that it can be said that that person is specifically affected by the decision. That is insufficient. What is crucial is for the person to be able to assert that his rights or his interests or legitimate expectations have been affected by the decision, and he can show a specific and identifiable right, interest, or legal expectation that has been affected by the decision. So a general claim or a broad claim that a decision affects him or her would be insufficient. There has to be a specific and identifiable and certainly not remote claim that a person's rights, interests, or legitimate expectations have been affected.
And I suppose in this case, Manjo, he doesn't have a right to whatever allowances or budgets or whatever. That's not a right.
That's right.
It's policy as such.
That's right. So that's exactly the point. So Scott here made a crucial point. As far as the rights of Manson are concerned, those rights actually depend on statute. They could depend on the Constitution. Obviously, the Constitution does not grant that right. It could depend on a statute, meaning a law. It could depend on a regulation based on a law, or it could depend on a common law right or a right recognized by the courts. But in this particular case, it is very difficult for Manson to claim any specific right, because any legal right that he might claim can be said to rest with the Parliament. So if Parliament decides to change the rights, in particular in relation to benefits, it is for Parliament to make that decision. And in this particular case, it is not even a parliamentary decision. It is a decision of the Minister of Health, which raises the question, what is the significance of the fact that the Minister of Health made a ministerial decision relating to the allocation of a budget? Can somebody address that point? So there is a ministerial decision, and I'm not talking in this instance about legal standing. So correct, as a solicitor, you would be correct in advising Manson that he does not have legal standing. That's right. Would there be any other reason why Manson's attempt to seek judicial review would fail, apart from the question of a lack of legal standing? And I'm talking about the ministerial decision.
Yes.
Yes? Who was that?
Sorry.
Yeah, it would fail, Manjo.
Is it all right I go to Lauren and then we go to you? That's all right. Yes, Lauren.
I'm sorry, I'm too slow to hit unmute. I guess the issue I had that, as some of the students alluded to a little bit earlier about how it's just a policy decision, is that under judicial review it needs to be a justiciable decision. So that in this case it's or is it a non-justiciable, in that the court wouldn't question the executive's decision to create a program raising awareness about men's health, because it's seen as a non-justiciable issue topic, is the way I understood it.
Very good, and that's actually correct. Now, can somebody tell us what exactly is Lauren referring to when she talks about justiciability, a justiciable decision? What exactly does that mean? I wonder if Scott would like to elaborate on that point, or somebody else. So Lauren is talking about justiciability. What exactly does that mean?
That you're sort of acting within the sort of authority that you've been given to make the decisions that you make. So I sort of, from what Lauren was saying, and just sort of about it being a ministerial decision on a budget, I kind of see that as, so, you know, the legislator or the sort of parliament are saying, okay, Mr. Minister, you have authority to sort of do and say X, Y, Z, A, B, C. But then within that, they then have the freedom to kind of do with that authority what they please, obviously without it being illegal or, you know, unjustified or, yeah.
Thank you.
Does it go back to it? It's more a political discussion rather than it having legal standing in terms of whether it's a justiciable issue or not?
You're correct. And before I elaborate on that, I wonder if Karen wishes to say something, or perhaps Marjorie. I see them putting something in the chat box. Karen, would you like to say something?
Yeah, I was thinking that this is just one of those decisions in the day-to-day running of the government. I mean, nobody's going to complain when the government buys its photocopiers or its computers or whatever. Same as the decision for McDonald and is it Hammett's? For just that it doesn't require a special legal authority because you're not interfering with the rights of the people. So therefore, it's just one of those things that government can do in its day-to-day operations.
Okay, and so in that case, the decision, therefore, is, as you pointed out correctly, it's certainly authorized because you don't need a specific statutory authority to do this. Now, and at the same time, as both pointed out by Lauren and Tamara, there is that, and I think Scott as well, there is that point about the justiciability question. And I was hoping for somebody to enlighten us more. What exactly is this issue about justiciability? And I think Lauren was talking about a political decision having been made. So if it is a political decision, so what?
Well, the courts, sorry, Manjo, the courts will not interfere with political decisions.
Why not?
Where I think it was Wallsend, Minister for Heritage or something in Wallsend.
Yes.
They said if it's a political decision involving political considerations, then that's a matter for the executive. However, if it's a matter involving legal standards, then that's a matter for the judiciary.
Very good. Thank you, Scott. So there are actually two reasons why, if a decision is a political decision, courts will not interfere with a political decision. First, because if it is a political decision, obviously the criteria that would have been used by the executive would be political. It could pertain to policies, it could pertain to national programs of action. Whereas courts make decisions on the basis of what is lawful. So courts make a decision on the basis of legal criteria. They don't make decisions on the basis of policy considerations or on the basis of political considerations. These are foreign to courts. So that's one. But the second point is that on the basis of separation of powers, as Marjorie pointed out, the the executive as well as the parliament are actually elected by the people, and therefore being the elected representatives of the public at large, these elected officials are given the authority on the basis of a representative democracy to make decisions on behalf of the people. So that is a political decision, therefore, that the elected officials are making in behalf of the people, and it is not for the courts, therefore, to second guess or to examine the propriety of the decision making made by elected officials of the executive. Very good. Okay, now, so we've come up with 3 reasons, therefore, why as a solicitor you would advise Manson not to seek judicial review. So there are 3 reasons. Could somebody again summarize those reasons for us? So what are the reasons again? Why would you advise Manson against seeking judicial review? What are the 3 reasons? Just to sum it up.
I'll give it a go, Manjo,
Yes.
if you like.
Mm-hmm.
1, he has no standing.
Yes, very good.
2, it's not suitable for judicial review because it's a political decision rather than a matter of law.
Mm-hmm.
And 3, the AAT has no standing to review it. There's no legislation enabling the AAT to conduct a merits review into the matter.
Okay, so there's a 3rd. So there's a 4th reason in relation to the claim that the decision is unauthorized. So in other words, is there a need for a specific statutory authority for the minister to be able to make this decision? That's the 4th one. So if yes.
Oh.
Go ahead, Lauren.
Sorry, I was going to tell you that the 4th reason is because the decision is authorized. It's not an unauthorized decision because old mate doesn't have, his rights have not been affected by the health minister's decision to implement the awareness program.
Okay.
I was just going to repeat what you just said. Sorry.
Okay. But I wanted to talk about the decision being unauthorized. It says there, Manson considered an application on the ground that the decision is unauthorized. So my question was, is there a need for a specific statutory authority for the Minister of Health to be making this type of decision? Is there a requirement?
No.
Who was that? Who said no? So can somebody elaborate on that point? So the 4th reason is that there is actually no need for a specific statutory authority for the minister to be making the decision. It's part of the exercise of the executive executive power. Okay, and so therefore in that case, the decision would have been authorized as an exercise of executive power, and the only time, as we said, where there would have been a requirement of a positive law or a specific statutory authority for the executive to make a decision is when that decision would have adversely affected the rights, interests, or legitimate expectations of persons or subjects of the Commonwealth. Questions, comments? Okay, so let's go to the, yes?
Yeah.
Grace.
Manjo, what I found that under the Section 91D National Health Act 1953, the minister has the authority to make a decision in relation to improvement of health or the prevention of disease. So in this case, the minister might really have a legal authority to make the decision what he's making. So he might have also the legal authority as also the political authority to make it.
Okay. Thank you for coming up with that specific law, Grace. But it raises the question, assuming that this law did not exist, assuming there was no such law, would you then be able to claim that the decision would have been unauthorized?
No, probably not. I agree with the previous speakers that they said that if this is a political decision based on the will of the people, that they elected the government, then probably the ministers got the power to make this decision.
Yeah, so even in the absence of a specific statutory authority, the decision would have, the minister would have been able to arrive at this political decision or at this decision. It would have been lawful. Now, let's go to that specific law that I'm interested in pursuing that question for a while because it relates to administrative law. So there's the National Health Act of 1953 Commonwealth, where if you look at the chat, and this is not going to be visible to those who will be looking at the recording later on, it says that under Section 9, subparagraph 1D of the National Health Act of 1953 Commonwealth, the Minister of Health has the authority to make a decision in relation to improvement of health or the prevention of disease. Okay, so let's ask a question in relation to that. You would have heard of SARS, which is, what was that? Do you remember the SARS syndrome? That's when some kind of a respiratory illness. It happened a few years ago in Hong Kong, I think, where they ended up quarantining certain people. They were not permitted to leave their homes because they would spread the disease. So imagine that you have a contagious disease that's in a specific locality. And what the minister has done is to quarantine and say, people, you're not permitted to leave your homes because you might spread the disease. So you got a problem? So let's assume that the Minister of Health, and let's assume that this act did not exist, okay? So let's assume that there was no National Health Act of 1953. So the question is, the Minister of Health, it has been reported that there is a very contagious and deadly disease that is spreading. And they've identified the focal point of that disease, ground zero, to be in a certain suburb or even a certain town. And the Minister of Health has made a decision for the purpose of protecting the safety and welfare of the citizens of Australia. He has made a decision to prohibit people from traveling outside of a certain suburb or even outside a certain town, and even force people to stay in their homes as part of quarantine measures. The question is, do you suppose that that decision would be subject to, I'm not going to ask judicially. So the question is, if you were one of those people living in a home that was subject to a quarantine and you couldn't leave it, so you called your lawyer by mobile phone and asked, what are your legal remedies? What would you suggest or recommend or advise your client?
I would be inclined to say that they couldn't sort of seek judicial review, because if the executive authority is to make decisions on behalf of the public, well, they're making a decision on like the sort of public in general to sort of ensure their health and their safety. So by quarantining, a deadly contagious disease, well, that's the executive's way of trying to bring it under control. But I suppose the flip side of that is if you are quarantining people, if you like, by sort of saying you've got to stay in your home, well, then what is their access to healthcare services? If they've got this SARS or they've got symptoms of it and they're quarantined, where's the provision for either them accessing health services or vice versa? So, but yeah, given the fact that it's in the interest of the public as a whole, I don't think that there's really sort of, or could be much standing for sort of questioning the legality of the decision anyway.
Thank you, Tamara. Any other comments from the rest of the class?
Yeah.
I agree with Tamara.
Okay, Maria, then we go to Scott. Yes, Maria?
Oh, I agree with Tamara. I was going to say that it's part of the government's duty to protect the community as a whole.
Okay.
It's for the general, like the whole community is gotta be protected from what, say, for example, the contagious disease. If it inconveniences if it conveniences somebody, well, he just has to put up with it. Really.
Thank you. How about Scott? You wanted to say something?
Yeah, look, morally, yep, agree with Maria and Tamara. Legally, no.
Okay.
Legally, your client, it's affecting his rights. So he's deprived of his liberty.
Yes.
So if it's a decision affecting the person's rights, then there must be legislation in place for the executive to make that decision. If that act doesn't exist, then their decision to quarantine that person is ultra vires and they can't do it. So they would have legal standing to conduct a review, and it would be a judicial review because they're looking at the legality of that decision to quarantine the person.
Very good.
So in essence, morally, yep, that's what should happen. Legally, I think he's got a good case.
Very good. So that is the correct answer. So the correct answer is that provided by Scott. Under the conditions when people are being quarantined and prohibited from leaving their homes, that obviously means that their rights to liberty would have been infringed and impaired, and there is a common law right against detention. There's also common law right to freedom of movement, meaning these are rights recognized by the courts. So if a decision of the executive infringes upon these common law rights, as we know from the principle of legality, there is a requirement that there must be a positive law. In that case, a specific statutory authority that would authorize the executive to make such a decision, such as quarantining people. Okay, and there is a... Yes.
Manjo, sorry. I most certainly don't disagree with Scott at all. He's very much correct. But say, for example, sort of as we're already established, this sort of person would have standing for a judicial review of the sort of quarantining in the decision. What could possibly be the outcome of that review? Because if it's a pandemic or epidemic, I can't remember which one's what, but there's got to be some way of containing that disease. So when it's concerning the public as a whole, not just one person, but everybody, yes, okay, quarantining is it's sort of going against the freedom of liberty and movement. Like, I totally get that. But how else are you meant to bring it all under control to the point where you will get your liberty back and your freedom of movement and etc.? So, yeah.
Can I jump in and add something to that? Totally kind of left ball, but a little bit related, is that in 2009, I ended up with swine flu when we had that massive epidemic in Australia. And to the point that I started to throw up blood, my dad had to rush me to the ER, and I was rushed through a full waiting room because my health was very bad, and they were very concerned about me because I had come into contact with someone who wasn't in quarantine who also had swine flu that I contracted it from. So in the case that, I understand the moral and the legal arguments as to why it could not be enforceable, but what would happen in that instance if your client somehow managed to contract this very contagious disease that then passed it on to a baby who died because they wanted to argue, well, I've got my freedom of liberty to be able to leave my house and you can't detain me because you've made this decision? What would happen in a case where, as Tamara said, then the rights of other people to be,
that's right,
I guess, safe from such diseases? I mean, this just brings to mind vaccinations for me and children, but that would be interesting to see when that group talks about it, that have chosen it for their group topic. But I'm just wondering, what would have happened if someone tried to tell me you need to be quarantined because you have swine flu, and I turned around and said, well, there's no law that says it. So
we won't have the chance to answer that question tonight. We don't have the time. So, but thank you, Lauren, for sharing your personal experience about the swine flu. I wanted to go back to Scott. Scott, I suppose you wanted to say something.
Yeah, I was just going to touch on what Tamara was saying. That's why this legislation is in place. The legislation exists, and we went on to the hypothetical saying it didn't exist, but it does exist, and that's exactly why it exists for Lauren's case, and what Tamara said is, that's why the legislation is there, to give the executive the power to do that. So it does exist. So we're in the space where it doesn't. We just went on that political space. That's all.
Very good. Thank you. I saw Karen raising her hand. Karen.
Yeah, I was just going to comment that surely it was something similar during the war, for instance, when you travel to certain areas because of military installations and things. And I'm assuming that there was wartime laws or regulations that were enforced.
That's right.
To provide the basis for those sorts of decisions.
That's right. So it can be questions like, setting curfew, providing roadblocks because there is a threat of terrorism. Would it be permissible for the police to block people from, disallow people from leaving homes because of the danger of terrorism? And again, it goes back to the question of, is there a positive law, a specific legal authority that enables the police to do that? But I'd like to leave this topic for now. Okay, I'm just going to read a comment of Benjamin because I'm aware that it's almost 7 o'clock. So I have a comment from Benjamin. There's already a precedent to this though. The bubonic plague, surely we wouldn't consider the possibility of such legislation not existing in modern context. That's right. So that's exactly the reason why the Commonwealth Parliament passed the National Health Act of 1953, precisely to provide a positive authority to the Minister of Health to take action, perhaps relating to quarantining people if it is required by the exigencies of health and medical issues. So I'd like to move on to the final question, and I wonder if we have the time to discuss this though. And this is in fact related to kind of what we had been discussing about quarantine, because the point there is assuming that there is in fact, so I'm going to kind of paraphrase this problem just to suit the initial question we have. So assuming that there is a claim or an assertion by the Minister of Health that there is a major problem with a disease. So there is a contagious disease around a specific neighborhood, and assuming that there is in fact the legislation, the National Health Act of 1953, which authorizes the Minister of Health to declare certain areas to be subject to quarantine. Okay, so I'm going to skip this problem for now. I'm going to change the facts a bit. I'm just going to link it to the question we were talking about earlier, or should I talk about this? So, because the question I would have had was, assuming that the Minister of Health exercises a decision on the basis of the National Health Act or a law passed by Parliament, would it now then be beyond the power of the courts to review that decision on the assertion by the minister that he is authorized by a positive law? And we're going to just go through this quickly because I've got another class at 7:15. So I'm just going to go through discussion question 4 so that we don't really end up being too much off topic. So claiming broad powers under the Australian National Security Act, Commonwealth, the Australian Security Intelligence Organization Director General of Security ordered the arrest and detention for a period of 90 days of Jameson Ibrahim, an Australian citizen who was alleged to have recently committed atrocities in Syria. Ibrahim's solicitor filed an application with the Federal Court of Australia for judicial review of the legality of his continuing detention. The ASIO Director General of Security asserts that the detention is legal since it is authorized by the Australian National Security Act, Commonwealth. So there is an authority which provides that the ASIO Director General of Security may cause the arrest and detention for a period not exceeding 120 days of any person who he considers on proper evaluation to be a threat to national security. So there is a law. There is a positive law that authorizes the Director General of Security of ASIO to make this decision and action. Advice on the validity of the ASIO Director General of Security's argument. So there is a positive law. Is that the end to it? Would it still be possible to question the decision of the ASIO Director General?
You might be able to say something surrounding the proper evaluation to be a threat. I mean, are we talking about his ex-girlfriend that's phoned up and concocted some story about it, or are we talking about weeks and weeks of police surveillance and wiretap and all that sort of thing?
Very good. So what Karen has pointed out is that even assuming that this positive law does exist, it's still within the power of the courts to examine whether or not that that decision has the authority behind the decision. If that decision was exercised according to law, so there will still be there would still be scope for judicial review of the exercise of that authority. Okay, so that's certainly one of the grounds. That's right. How about the second point? Is there anything else? As a lawyer, would you be able to provide an advice in support of Jameson Ibrahim's claim that the decision of the ASIO Director General is unlawful? Assuming that there is a law that supports that.
Manjo, I'm just sort of more looking at the wording of the problem, if you like. So it says that an Australian citizen who was alleged to have recently committed atrocities in Syria, and then the wording in the provision is may cause the arrest and detention for a period not exceeding 120 days of any person who he considers on proper evaluation to be a threat. So is he just going off the fact that, you know, sort of somebody, or he's heard that it's alleged that this person has done these things, as opposed to this person having been properly and appropriately monitored and evidence collected and sort of that sort of thing, for them to then go, okay, we've properly evaluated what we've been monitoring and what we found as that results, and now we're going to arrest him, if that makes sense.
Well, let me answer that. In relation to judicial review, it would in fact be difficult for judicial review to be availed of if the legal question that is raised is that the Director General improperly exercised his power to properly evaluate a person, whether or not that person is a threat to national security. Because that relates to propriety. That relates to a factual question that is not subject to judicial review in general. Okay.
Manjo, if I may.
Yes.
I think the law is ultra vires.
Go ahead.
I don't think the executive has the power to detain someone's liberty. Like that detention has to be established as lawful before a court of law.
Say it again. Say it again.
The detention of that person has to be established as lawful before a court of law. The executive can't make decisions just to deprive people of their liberty willy-nilly, or as in this case. That's unlawful. Even though it's in legislation, I think the authority is ultra vires and therefore should be struck down.
That's right. That is the correct answer there. Even if there were such a law to be passed, it would still be within the power of the courts to examine the lawfulness of that specific law. And in this case, the courts would likely say, following, for example, the case of Hicks versus Roddock, that it would be within the power of the courts to examine the legality of the detention of a person, especially a citizen of Australia. Because what then happens is that it is within the power of the courts. It is only the courts in general which have the power to allow detention as a form of punishment. If the detention, say, were about a week or even 2 weeks or 3 weeks, then it could be argued that perhaps the detention was a form of protective custody. But if it is for a period of 120 days, that clearly is a punitive measure. And under our laws, only the courts have the power to detain a person when that detention would then be arguably a form of punishment. And in this particular case, because the period of detention would have been for a period of 90 days, that would amount to a punitive measure and no longer some kind of a protective measure. I saw a message there. One new message. Okay, from Grace Jameson Ibrahim. I also have evidence. He was not visiting Syria in a period he was accused of. Okay. But in that case, again, that is a factual matter. So if it's a factual matter, it would likely be not within the power of the courts to review. But again, what needs to be pointed out is that apart from judicial review being based on the on the Administrative Decisions Judicial Review Act of 1977, under Section 75 and Section 75, under Section 73 and Section 75 of the Australian Commonwealth Constitution, it is within the power of people, of citizens, to file an action when it involves decisions by officers of the Commonwealth. And under Section 75, the High Court has the power to issue writs of mandamus, prohibition, and injunction against officers of the Commonwealth. Okay, Any questions? From Benjamin, doesn't our concept of legal, non-legal detention stem originally from the Magna Carta? Perhaps, yeah, but the Magna Carta would have been, of the UK, would have been possibly, but yeah. And as a result of the Magna Carta, arguably, I suppose, that's how the courts have arrived at the recognition of certain common law rights against arbitrary detention and arrest. Okay, any other questions before we end tonight's session? And thank you for your engagement and your participation. I've got a class at 7:15. Any questions before we end tonight's session? None? Okay, so thank you everyone, and I'll see you again next week. Good night. Bye.